You're appearing here today.
By special appearance.
I understand what you're doing and what you're trying to do. It's not going to help you a single bit in court to try to play these games.
And child subject matter jurisdiction going on record.
Okay, what does that mean?
Overstand.
You just determined to use different words and be difficult, aren't you? Good morning. Are you Nasir Brown?
I'm not here today on special appearance.
I'm sorry. Speak up so I can hear you.
Here today
You're appearing here today.
by special appearance.
Okay, what is your name?
I'm a third party intervener on behalf of artificial legal entity Nasir Brown.
Okay. At one point in your at some point in your life prior to being this third party, were you Nasir Brown?
No.
You're not him.
I'm a third party intervener.
So here's the thing. If you don't tell me your name, I'm going to put you in custody for not cooperating this morning. I'm not going to hold on. I understand what you're doing and what you're trying to do. It's not going to help you a single bit in court to try to play these games.
That's relative.
So are you Nasir Lewis Brown, or have you been him at some point in your life or not?
Yes.
Okay. So I'm going to call you by Mr. Brown because I'm not going to say all the words that you just said, because you have now identified yourself as Nasir Lewis Brown. And so, Mr. Brown, this is your initial appearance, and you have two cases. And cause number 26, I just asked you not to speak over me. So here's the thing, Mr. Brown.
This moment is incredibly important because it highlights a tactic judges across the country see more and more often. Defendants attempting to separate themselves from their legal identity by using phrases like special appearance, third-party intervener, or challenging subject matter jurisdiction without any legitimate legal basis. In many online circles, people are told these phrases somehow remove the court's authority over them. But in reality, courts almost never accept these arguments. Notice how calm and controlled the judge remains here. Instead of immediately escalating the situation, she repeatedly gives the defendant opportunities to cooperate and answer basic identification questions. Legally speaking, this hearing is actually very routine. The judge is simply explaining the charges, bond conditions, and the defendant's right to hire counsel. But because the defendant keeps trying to interrupt with unusual language and non-standard responses like overstand and oblige, the hearing becomes far more tense than it needed to be. What's also interesting is that the judge subtly shifts strategy. Rather than arguing with the defendant about these pseudo-legal theories, she focuses on practical consequences, reminding him that failure to cooperate or follow bond conditions could send him right back to jail. That's often how judges handle these situations. They avoid debating internet legal myths and instead redirect attention back to the actual court process. Viewers, what do you think? Was the defendant genuinely confused about the legal system or intentionally trying to disrupt the hearing with sovereign citizen-style arguments?
I'm going to be very patient.
And the child subject matter jurisdiction going on record.
Your challenge of the subject matter jurisdiction is overruled. Let me go through what I need to go through, okay? So this is your initial appearance, your first day in court. I'm required to go through what you're charged with by indictment. In cause number 26, DCCR 0322, you're charged with a third-degree felony offense of assault family violence by impeding breath or circulation from February 16th of 2026. And then in cause number 26, DCCR 0323, you're charged with the state jail felony offense of injury to a child, and that's from February 16th of 2026. And so since you have made bond and got out of jail on your cases, have you had an opportunity to try to hire a lawyer? Speak up so I can.
Up and down.
It's been up and down?
Yes.
Okay, so here's what I'm going to do, Mr. Brown, is I'm just like everyone else. I'm resetting your case about 30 days to give you some time to try to hire a lawyer. You need to try to get someone hired before the next court date. If you do, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand? I'm sorry,
Overstand.
say it
They
again.
overstand.
You overstand?
Yes.
Okay, what does that mean?
Overstand.
Do you understand what I'm saying, sir?
Not blind.
You'll
Blind.
oblige.
Blind. Yeah.
Okay. You just determined to use different words and be difficult, aren't you?
Not at all.
Okay. So as a condition of your bond, did you have a condition that you were not to have any contact or communication with the complaining witnesses in each of these cases, right? Okay, and so I want to make sure you understand the importance of that. And that if you do have any contact or communication with either of them.
By the end of this hearing, the judge had made one thing absolutely clear. No amount of wordplay, alternative phrases, or courtroom theatrics was going to stop the legal process from moving forward. Despite the defendant repeatedly attempting to challenge the court's authority and avoid standard responses, the judge stayed remarkably patient while still maintaining full control of the courtroom. Legally, this was a straightforward initial appearance involving serious allegations, including assault involving family violence and injury to a child. The court's primary goal here was to explain the charges, ensure the defendant understood his bond conditions, and give him an opportunity to obtain legal representation before returning to court. But the unusual responses and constant interruptions transformed an otherwise routine hearing into a tense courtroom standoff. One of the biggest takeaways from this case is that internet legal theories and sovereign citizen-style arguments rarely hold up in real courtrooms. Judges focus on statutes, procedures, and compliance, not creative wording or attempts to redefine legal identity. And when defendants refuse to cooperate, the consequences can escalate very quickly through higher bonds, contempt issues, or even jail time. If you found this courtroom showdown as wild as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
It would be a violation of that bond condition if I find out your bond would be raised and you would go back to jail. Do you understand that as well?
Overstand.
You overstand.
Same thing.
I'm going to guess that overstand is even better than understand. So you definitely know what I'm talking about, right? So we don't have any miscommunication today. You know exactly what I'm talking about. So I'm going to have you step in front of the clerk. You're going to sign a reset notice so you know when to be back in court and take care of those things before the next court date. All right, step in front of the clerk.